Abusia beda masene amama kwa abade maba Ayeka TV so we amosomfo KVS abusia ena so yatena se Ghana maimu nsem de ekọ ene de ba na mede ho asem nyina eba abeso mu nti abusia wonya subscribe ya no abomode anu subscribe comment section won so eni die kwan so na wa kire wa adwen honum na bibia aye kama abusia Chief Justice Honsensema His Excellency John Dramani Mahama kire se Nipakuo miensa bi atro petition na de abre ono His Excellency John Dramani Mahama say Chief Justice edi ndwuma bi a sa adwuma na Chief Justice edi no omu kiremu a ekotia constitution no nti wo say His Excellency John Dramani Mahama ehwehwe nsem no mu na odi yi Chief Justice efiri honum na odi new Chief Justice eba na asem ne ba ye ne de eho asem aba be ye he wo mani mu a asat now asem no okota just say I put it to you objection overruled ahodo a ekoso no na enya asem ketua na ene I put it to you any objection overruled no na ye between Godfred Odame and Justice Kulendi na ene ensem a esi wo court ho de abusia enya asem ketua wa bra Justice Godfred Odame person o kire se eye His Excellency John Dramani Mahama abrichi eye constitution ni process na offer so nyina no a constitutional breach also and a Justice Kulendi episode kire a Godfred Odame say processes now His Excellency John Dramani Mahama so ne de the right process into omubusa Godfred Odame questions no yi anu no omubusa no yi anu in some course wo court one me de abusuya enya asem ketua enti audio ni nyina ba be kan Ayeka TV mensa me ba be play na abusuya onso anya biatie ti unya subscribe ya no abomode anu subscribe in 10 times yenko tie insem a ekopie mu e wo honum nyina.
Justice Kulendi says, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? Justice Kulendi puts the question to Godfred Dame, the former Attorney General. He says, Mr. Dame, let me ask you, in the case at hand, what will be the substantive constitutional breach in respect of the respondent's conduct? The respondent being the president, by the way. The respondent is the president. The applicant is Asifwa. The respondent is the president. Then Godfred Dame says, my lord, the failure to give the Chief Justice notice. So Justice Kulendi says, what will be the substantive constitutional breach in respect of this? And says it is the failure to give the Chief Justice notice. That's what Godfred Dame says. Simplifies the matter. Then Justice Kulendi continues. It is a question of time as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Justice Kulendi was piling pressure on Justice Godfred Dame to demonstrate where is the constitutional breach. Show me the constitutional breach. Is it what is the point? Article 146 says what? Does it say when, at what time? It doesn't say. That's Justice Kulendi's question. Let me read it again. It says it is a question of time, comma, as to when the notice be given. Show us anywhere in Article 146 where the time is set as to when the notice to the Chief Justice ought to be given, as such violation will be a manifest constitutional aberration. Godfred Dame says the Constitution is silent on that, and that is the essence of the constitutional issues before this court. I like the banter. The judge says, show me where the thing is. The lawyer says, it is not there. That is why you are here. The purpose of the Constitution, the Supreme Court, is to give clarity to things that are either not in the law that ought to have been there, or things that lend themselves to 2 or 3 interpretations. That is the essence of the court. If there was a black and white situation, Article 146, we will not be here, my lord. We will not be here. We are here, and you, your lordships, are empowered with experience and learning and teaching that can help us to be able to go through this process in a way that a constitutional court works. That was the banter between Justice Lord Kulendi and Godfrey Dame. But as if Professor Mensah Bonsu was listening to both of them, she then entered into the fray with Justice Sremsai in this way. She said, the right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Address the court on this, Learned Attorney General. Address the court on this. So she makes a substantive statement and says, listen, the right to be heard is a constitutional right, and Article 23 requires that administrative justice should respect this right. Please address the court on this one. And then Justice Sremsai, the Deputy Attorney General, says, my lords, the right to be heard has been provided in the procedure outlined Article 146. Hence, the issue is at what time the enjoyment of this right is to be respected. At what time the enjoyment of this right is to be respected. And then Professor Mensah Bonsu says, should the enjoyment of this right accrue after the respondent, the Chief Justice, has been tried in the court of public opinion? Sremsai says, my lords, I rest my case. So they are talking about rights. Professor Mensah Bonsu says, it is a right for everybody to have the right to be heard. Show me how this right should be enjoyed. He says Article 146 provides that the right can be enjoyed, but it doesn't say at what time the right should be enjoyed. You see, the president gets the petition, sends it to Council of State. The argument is that president gets a petition, send it first to the subject before the Council of State can have the petition and what the subject says, so that they can come to a conclusion of a prima facie. But you don't send to the Council of State only one side of the story and ask them to do a prima facie. This is the conversation going on. And they are saying that where, at which point? And Professor Mensah Bonsu is saying that, okay, if you're asking me at which point, or that the Constitution is at which point, are you suggesting to me that it's okay for you to give the document to the person after you have tried the person in court of public opinion? That is to say, after everybody has seen the petition and is going to Council of State, is it at that time they are going to give the person the right to be heard? After the public has seen, after the Council of State has seen, after they may have prejudged the matter, after they may have made their opinion, is it at that time that you are going to show to the subject? This was a conversation between Professor Henrietta Mensah Bonsu, who was on the minority side, writing the minority opinion of 2, and Justice Sremsai, who is the Attorney General's Deputy Attorney General and Deputy Minister for Justice. Justice Sremsai, in answer to the rhetorical question by Mensah Bonsu, said, my lords, I rest my case. Applications were made for the coverage, the live coverage of this case. The first application made here was by the Law Platform, and we know that Justice Tokonu was allowing the media to cover cases live, and all of us were very excited about it. So the Law Platform wrote that the Law Platform is an online law magazine available at www.this. The magazine is dedicated to the publication of legal news, legal articles, etc., etc. And they said that owing to the huge public interest in the matter, that the matter holds for the benefit of the members of the bar and public at large to have the opportunity of full and live proceedings in this landmark case. We are humbly hopeful of my lady's request. That's one judge that Tokonu was there. The application was repeated to Justice Bafuboni, and it didn't quite happen. Now, 2 days ago, yesterday in the morning, we came here and we discussed this, and so we put out this letter to the Lord Chief Justice, and we'll read a little bit of it. Vincent Ekwasifo versus the Attorney General, and it says here, now I signed the letter here in the office to send to the Chief Justice for live coverage by Good Evening Ghana and Metro TV, and this is what we wrote to the Chief Justice, that I am Paul Adumochiri. I should have added blogger Bakope. I should have added that I am Paul Adumochiri, blogger Bakope. The host and producer of Good Evening Ghana, a Ghanaian primetime current affairs TV program which airs on Metropolitan Television, and I write to your outfit to pray for leave to provide a live coverage of the proceedings of the 6th of May 2025 in the case of Vincent Ekwasifo versus the Attorney General. The practice of giving the media the opportunity to cover high public interest cases in the superior courts of judicature has become conventional in the political and legal landscape of our republic. From the 2012 election petition, where the then Chief Justice, Honorable Lady Georgina Wood, through an administrative fiat, granted permission to the media to provide a live coverage of the proceedings in the said case. This was hailed as a step in the right direction, which sought to deepen our democratic culture and heighten public interest in the judiciary. Subsequent to this pivotal period in our history, the judiciary has placed its shoulders to the wheel in ensuring the publicity and coverage of such court proceedings in the cases such as 2020 election petition, John Mahama versus Electoral Commission, Alexander Markin versus Speaker of Parliament, Richard Delaskai versus Parliament of Ghana, in line with the aim to foster transparency and interest in judicial processes by the common man. It is the humble prayer of my production team and myself to be granted the permission to cover the proceedings of court on 6th May 2025 in the case of Vincent Ekwasifua versus the Attorney General. This will aid in promoting and deepening the culture of democracy while equipping the interest of the public in the court system and in our democracy. Yours faithfully, Paul Ademochi. Viewers, I signed this and we were not allowed to show it. I don't know whether it's as a result of lack of time. I'm not sure what it is. But I'm pleading to the acting Chief Justice that if the matter comes up on review, all of us, the media, are going to put out these kind of requests. And we're expecting that in following the best practices of your forebears, the Lord Chief Justice, Justice Paul Bafuboni, will allow the media to film inside the courtroom the applications for the review of this matter before the Supreme Court, because Ekwasifua has asked for a review. The circumstance of the review is that 2 judges are going to be added to the 5 that have made the determination. 3 on one side, 2 on the other side. 2 judges are going to be added. If all 2 judges go with the 2, then that will be 4-3. If all 2 judges go with a 3, then that will be 5-2. If 1 judge goes with a 3 and 1 judge goes with a 2, that will be 4-3 in favor of the 4-3 against the application. That's what it will be. We are hoping that now that Justice Paul Bafuboni has had a bit of time, if the review application is filed and a date is given, we are going to send him letters asking him to allow us to film for Kwabena Edubuahin was returned to courts. And what happened on Wednesday is that after he had been invited to Iyoko or so, he was told in the afternoon that the court process is waiting and that he has been charged. So together with his lawyers, they went to court. When they went to court, it was about 4 p.m. in the evening, as I'm told by the lawyers. The court was sitting. The judge was already there. That surprised Atachan a bit. Because it was 4 p.m. and typically judges would have closed by 4 p.m. But on this occasion, the judge was there. And then the Leonard Attorney General, Leonard Dominic Ayeni, made the case that he was interested in keeping Kwabena Edubuahin in for a while, pending his investigations. And the judge said he should come and argue that on Friday. Atachan said that on Friday when he was going to court, he was aware that no judge was going to grant something like this, because as Atta said, and I don't know whether you still have the words that Atta used that I sent to you. If you have it, make it ready and I'll show it at the end of this. As Atta said, it is incongruous to understand how the Leonard Attorney General has kept Kwabena Edubuahin in for 2 or 3 weeks, held a press conference and indicated all the offenses of Kwabena Edubuahin in a press conference. After the press conference, the court grants Kwabena Edubuahin bail together with his wife, who takes him a long time to fulfill the high bail conditions. Atachan actually goes to court to amend the bail conditions. The court agrees with him and reduces the bail conditions to a certain 80 million Ghana cedis for him to find some evidence of 80 million Ghana cedis before he is let out to go. That happened and they let him go. And then after that, it took another 3-4 weeks before the Kwabena Edubuahin was formally charged. Atachan doesn't understand what more time the Attorney General needs. And indeed, on that Wednesday, the Attorney General returned to hold a press conference. He did. And said again things that Edubuahin had done and introduced new things. And while Atachan says all the allegations against Edubuahin will fall flat in the court, and Atta strongly believes in that nothing is going to work, everything will fall flat, he does not understand why the Leonard Attorney General is looking for more time. In fact, Atachan said that in his press conference, the Attorney General was talking about plea bargaining, that Edubuahin can come for plea bargaining. And Atta was confused that you have not presented any real evidence in the court against the accused person, and you're already asking him to come for plea bargaining on the whims and caprices of your decision that he is guilty, when you are not the court, you are not the judge. What kind of law is this, Atta fumed? What kind of law is this? He told the media. You are the Attorney General. You are prosecuting the man. You have found charges against him that must come to court and stand the test of time. It is in the process of you presenting this evidence before the court that the person will decide that based on this evidence, I will do plea bargaining. But then you are inviting him to do plea bargaining because you have filed charges. And Atta says that he smells a rat in all of these things. He also told the media that he doesn't want to pick phone calls from the Leonard Attorney General, that is his good friend. Attorney General has been calling him, that he has seen the phone calls, but he will not answer them. You know why? Atta is being very smart. He says he will not answer them because we have history where these people can record your phone call and come and say that you said this or that. And so in good faith, he doesn't want to talk to the Attorney General whilst the prosecution is doing the